I was really hoping that I would not have to contribute to the death by PowerPoint, which is usually the symptom of most conferences. But given that I can't impress you with my looks, I had no choice but to have some sort of PowerPoint. This is not a PowerPoint that's going to impress you in terms of any gizmos, graphics, visuals, etc. I don't have the skills that Kent brings in terms of visual descriptive capacities. So this is very much around ideas, and the purpose of the 20 minutes or less in the chair.
I'm watching the time.
I knew you would. I knew you would be.
I'm watching the time.
So I'll just try to wrap up before the 20 minutes, just to sort of one-up you on that one. The purpose in the 18 minutes or so that I have is to not necessarily find a lot of solutions to really complex problems, nor is it to give you a detailed description of the technical rules around conflict minerals and similar non-financial mandatory disclosure, but rather to use that as an example of a much more wide-ranging phenomenon that we are seeing not just in the United States or in the European Union, but in a number of jurisdictions, and to raise some questions about what these kinds of mandated disclosures mean more broadly for corporate law theory, and whether corporate law theory as is currently constructed is capable of answering these challenges. So the bulk of the presentation will be focused on the challenges and theoretical elements, and really what I'm seeking to do in the descriptive parts is just to give you a sense of the kinds of things that are happening. And so let's not get bogged down in the technical minutiae of what the rules themselves stipulate. And in doing the challenges for theory bit, I don't presume to have answers or solutions. Rather, what I have are sort of tentative conclusions that are in the nature of speculations, to which I hope you can contribute some ideas to help me refine and understand these issues better. So just to start with, there is, as you all are familiar with in this room, an increase over the last 5 years or so in the nature and claims being made of corporate disclosure, ranging from activism around the disclosure of spending by corporations on political donations in the US, again, Professor Bebchuk being a champion of that idea, to contributions to religious causes, charities, to investments in mine safety equipment, to conflict minerals, and so on. There is gender diversity is another one. There's an expanding array of causes to which corporate disclosure is being leveraged. And we've seen the diversity arena being a successful example of that happening. Conflict minerals is a second. Political spending, a lot of momentum behind it, and indeed this list could go on and on. Regardless of which political cause is being espoused, the challenges and the thematic issues that these raise are quite similar, and that's the claim that I'm making, and they raise fundamental challenges to what we understand to be the role of corporate law. So just to spend a couple of minutes on the specific issues raised by conflict minerals, and to give you an outline of the kinds of things that these kinds of laws come with. The conflict minerals laws came about following the seemingly brutal, even in the scale of Rwanda, etc., of a conflict in the Congo, with the financing of the conflict being very closely tied to the minerals trade, specifically the 3 T's, tungsten, titanium, and tantalum, and gold. The argument being that the groups were funding their conflict and the purchase of weapons, munitions, etc., through their involvement with these minerals. And the estimates range from the several hundreds of millions to the low billions in terms of how much funding was being devoted to these conflicts through this trade. Equally, there was a great degree of reprehension to these practices, and coupled with the impotency of the international law response to this conflict in the DRC, especially given the history in other conflict regions in Africa, it was felt that perhaps different approaches to resolving these problems could be taken. And one of those approaches might be disclosure through the securities laws. Coincidentally, the United Nations Security Council in 2001 and through a series of resolutions that culminated in this 2008 resolution, seemed to address member states through a direct invocation to use their laws so that they required more from corporations that were connected to these minerals, and the understanding being that these minerals were part of normal supply chains in the tens of thousands of corporations that do business in most Western countries. Alongside these developments in the United States, there was a high degree of activism led by politicians, Hollywood actors, entertainment industries types, so on and so forth, which talked up the humanitarian costs of DRC conflict minerals. We've seen movies about diamonds, conflict diamonds, the Kimberley process, all of that, which again reached its zenith in a series of bills put forward by Senator Sam Brownback, Congressman Brownback, sorry, at the time, who was a Democrat, fairly left-leaning, I think would be one way of describing him, which did not receive much support in the House. But following the financial crisis and when the Dodd-Frank Wall Street Reform Act was being passed, through the kinds of compromises and complicated deal-making that usually happens in Congress, this provision was snuck into a statute that was supposed to address the causes and consequences of the financial crisis, which of course was about subprime mortgages. So you have a statute which is supposedly addressing Wall Street mortgage financing, now containing a provision which resonates with the Security Council's language and then includes it as part of securities law reform. It's very important, and in the context of the maneuverings that I just described, to explicitly understand what even Congress admitted was the purpose behind sneaking in this section into the Dodd-Frank Act. It did not profess that this was a statute which had anything to do with subprime mortgages or curing Wall Street. It explicitly said in the preliminary language to the statute, to the section, that Congress senses that the exploitation and trade of conflict minerals in the DRC is helping to finance conflict and contributing to a humanitarian crisis. So the animating language for the section is not investor protection, Wall Street reform, but humanitarian. And yet it gets included as part of securities law reform, as part of the Dodd-Frank. So if that was the animating purpose, the substantive content of that intention is manifested in section 1502 of the Dodd-Frank Act. And there was another provision, 1504, which deals with something slightly similar but different, not relevant for our purposes. But 1502 imposes obligations on companies that either manufacture or contract to manufacture products which include conflict minerals, to disclose whether those were sourced in the DRC or 9 adjoining countries. And as part of that inquiry, companies are supposed to conduct some sort of a reasonable source of origin type inquiry and then disclose if those minerals actually originate in the stipulated countries. The statute also defines conflict minerals as being derivatives of these 3 T's, titanium, tantalum, and tungsten and gold, or their derivatives, and also carries an omnibus clause where the Secretary of State can stipulate other minerals or derivatives which are originating from these countries into that definition. In terms of the specifics of the disclosure, there is a new form that this disclosure is supposed to come and being filed under. The information is also supposed to be disclosed on the websites of the companies. And if indeed the companies find that there are conflict minerals are part of their supply chain in the things that they manufacture or contract to manufacture, they've got to file a conflict minerals report as an addendum to this form, and that CMR, or the conflict minerals report, is supposed to be audited by a third-party auditor. The Dodd-Frank section itself was at a high degree of generality, and it required rules to be adopted by the SEC for them to actually come into force. The SEC predictably dilly-dallied for as long as it could get away with, and this is a statute adopted or enacted in 2010. SEC did not do anything for the first year or so, faced increasing pressure to do something, issued a set of initial proposed rules, which activists claimed was too soft, came back with final proposed rules, which was a little more biting, and then issued those rules. The rules were subject to attack immediately from industry groups, which went to court. Portions of the rules were struck down, and we don't need to get into the details of this because the striking down was under US constitutional law. Specifically, a portion of the SEC's rules required companies to state that their products were DRC conflict-free. The DC Circuit Court found that the compelled speech saying that a product is conflict-free is a form of compelled speech that violates the US Constitution's First Amendment, so on and so forth. There was also arguments about whether the cost-benefit analysis and the process of issuing rules satisfied the Administrative Review Act, and so on and so forth. We don't need to get into those technicalities. The final result is that a portion of the rules was stayed, but the rules themselves survived. And I believe the SEC was seeking cert in the Supreme Court, and they had until a couple of weeks ago to file the petition, so I'm not sure where that's at. So it's very likely that the SEC itself will go back to the court to say the whole rules should stand. There's a period of uncertainty, but the rules actually still stand as law, with that small caveat about the DRC conflict-free portion. Subsequent to the rules surviving challenge, there's obviously a flurry of activity by companies to file reports, and there is some evidence in terms of what has been filed, which reveals a huge mass of confusion, because many companies are unable to find out if their supply chains include these minerals from the conflict regions specified, as you can imagine, for good reason, because the supply chains of these products are extremely long and often very opaque. So to give you context, the kinds of companies that would be under the purview of this are not necessarily companies that deal with minerals, jewelry, etc. It could be any company that potentially has some part of its production machinery, including something that is used, for example, in packaging. There was an argument made, and I don't know how credible this is, that Kraft, which was a company referenced by somebody yesterday, used some of these minerals in its chocolate packaging because of the foil containing some derivative of this material, etc. So it's that degree of involvement, from cell phone companies to iPhones, which contain one of these minerals, and so on. So the number of companies that could be caught into this disclosure regime run into the tens of thousands. And indeed, it's not just that it bites US companies, because as long as you're within the supply chain of a US issuer, you would be caught up in demands for disclosure from US issuers, who then have to certify whether they're compliant or not. So even foreign companies are caught up within the conflict minerals rules, and one of the arguments is whether this is a stealth extraterritorial application of US law. I mean, the US traditionally doesn't need stealth to apply its laws extraterritorially, so I don't know how credible that argument is, but nevertheless, that is possible as an argument, and therefore, this is not just about US companies or US law, it's potentially applicable to all kinds of companies in all kinds of parts of the world. The rules, as I said, contain a great degree of specificity and detail, not necessary for us to deal with it for the present. It suffices to say that the rules as issued and expected to be complied with are extremely costly for businesses. the SEC's own estimates, while it was making the rules, estimated the compliance burden initially at 3 to 4 billion and a subsequent annual compliance burden ranging from 200 to about 600 million. The industry associations predictably had a number which was several times more than this, and perhaps they were overestimating their compliance costs to the tune of about 16 billion, which is a multiple of 4 times the maximum that the SEC suggested. Tulane Law School conducted a different kind of approach study, which showed that the cost was somewhere between the SEC's estimate and the industry estimate. So whichever version you accept, the number is a big billion-dollar number. So massively expensive piece of law. So we've now come to a situation where we've got a rule about conflict minerals snuck in through the securities laws, supposedly in a statute to deal with Wall Street financial crisis. Extremely expensive. And then my suggestion is that this raises very serious challenges. First of these is, what is this rule about? This is supposedly a law to reform Wall Street practices, and yet it's about humanitarian law. So firstly, is it appropriate for human rights law or humanitarian causes to be snuck in under the guise of securities law? This is relevant, again, resonating back to the conversations we've had about soft law, hard law, etc., because law depends upon institutional processes, legitimacy, authority. If the law is about humanitarianism, how does it sit with the SEC as the institution, which is both issuing the rules and expected to enforce them? The SEC's mandate under the Securities Exchange Act of 34 is about maintaining efficient capital markets, investor protection, and disclosure related to that. It's not an agency to conduct human rights work. So then the question is, if you're issuing conflict avoidance laws or human rights law, is this illegitimate? Because it contravenes or vastly expands the legislative competence and the designated delegated authority that has been conferred by Congress to the SEC. The next question, even if you concede that, or under a very liberal reading, that the SEC has mandate and this is within its proper jurisdiction, how is the SEC, as it is properly constituted now, to enforce this? The SEC is not even able to enforce the disclosure of existing securities and investor-related disclosure. It's hugely understaffed, the quality of disclosure remains variable, it doesn't have the resources, so on and so forth. So how do you enforce something like conflict minerals disclosure? This point is not merely academic. The SEC itself and its commissioners in the dissent clearly accepted that the SEC was not the appropriate body for this kind of rulemaking. Because as Commissioner Gallagher said, 1502 is not about investor protection or efficient capital markets, it's about humanitarian intervention. We fully support this mission, but this is not our job. And that's a legitimate criticism if one understands institutional mandates, responsibilities, legitimacy as being strictly circumscribed by law. Because if it's not so, you have runaway institutions doing as they please. So it's not something to be dismissed lightly. The next category of challenges that this kind of law poses is about internal contradictions and inconsistencies. So take it as it is, being a good thing. Is this law designed to achieve the purposes? First argument, perhaps not, because it's counterproductive. If you now impose these kinds of diligence rules, auditing rules, etc., on US issuers and their suppliers, what you'll have is that businesses will flee from the DRC and adjoining areas because compliance burdens become too costly. So rather than helping poor people in Africa free themselves from conflict, you might actually be making them poorer, and therefore the purpose of the intervention might be defeated. The second is that this kind of law, well-intentioned, usually has unintended consequences. If conflict groups cannot use gold and the other minerals to finance their conflict, they're not likely to just cease conflict, but will use other opportunities to finance and fund the conflict, which again increases violence and other problems. Thirdly, there's regulatory arbitrage. Unless the whole world signs up to something like this, you'll have one country having high rules, people will migrate to China, etc., where such rules don't exist. You're losing your competitive position. The business itself doesn't stop. Finally, the rules, even taken in its most favorable light, don't actually say stop dealing with conflict minerals, or you, the company, is not supposed to use conflict minerals in your supply chain. It's perfectly possible for a company to be compliant in the sense that it discloses that it has conflict minerals, has an audit report which is all bulletproof, perfectly presented, etc., and continue to do business as usual. So what is the purpose? It's imposing costs for no real benefit. The second series of challenges pertains to the theoretical difficulties that this kind of law presents, and that's really what I wanted to focus time on. And I think I have about 3 minutes, so I'll try to do that as one does in these situations. The theoretical challenges present themselves around our understanding of a corporation. In law, at least the consensus view of the corporation is that it's a nexus of contracts. In that view of the corporation, the role of law is extremely thin. It's to be enabling, to fill in the blanks, to present default rules. It is not to legislate what a corporation should be or should do. Because the argument is, as rational actors, if parties to a corporation wanted that corporation not to deal with conflict minerals, etc., etc., they would provide through their own internal bargains for such protections without the need for the legislature to mandate it. Which is why corporate law, as we at least understand it today, resists this kind of imposition and says we'll only resort to incomplete contracting rules, enabling rules, so on and so forth. The second species of challenge pertains to interventions through law under the guise that it solves the principal-agent problem. This might be because of the information asymmetries that exist between the principals and the agents, and whether law can solve that problem. If you analyze the conflict minerals and similar laws under that framework, once again you're left with a conundrum, because one, you have an increase in the volume of information, and two, the kind of information that is provided may not necessarily address either the interests of the principals or their desire to do something about their agents acting in this way, because at least under the conventional model, the principal-agent model is again very tied to economic incentives. This doesn't necessarily address constraining agent behavior to suit economic incentives, because one could argue that dealing in conflict minerals actually is quite profitable. So the principals might not actually be concerned with this problem. The third is about institutional design and legitimacy, and this I've briefly mentioned with the SEC, so I won't go there. Information overload, I've done that. And finally, it gets me to the point that I was interested in teasing out, is about whether this kind of law alters the traditional understanding of materiality related to the principal-agent problem. The reason why we have the requirement of materiality as a constraint on disclosure is to protect investors in the market from an overload of information and to very closely tie the disclosure obligations to the kind of information that rational investors are likely to find useful. This is a principle that is outlined or established in the case of TSE Industries in 1976, and later accepted and affirmed in the same language in the case that most of you would have heard of, Basic and Levinson, where the court clearly said it has to be about the total mix of information that a rational investor is likely to assess, and whether what you have omitted would be considered relevant by an investor to that total mix in investment decisions, proxy or voting scenarios, and so on. And that then is about whether it is material in a decision-making sense from an economic perspective, which is how materiality has been interpreted in the case law. Now what we have is a set of information that is not about economic materiality, but about some other kind of materiality. So are we putting Basic and Levinson and case law, which are its progeny, on its head by changing the definition of materiality without explicitly doing so through these kinds of non-financial disclosure obligations? And if we are doing so, is it an acknowledgement that the understanding of corporations in law that we currently possess, which is a very thin conception of just profit maximization, shareholder wealth, and no more, to something very radically different? I mean, a number of us in this room have had side conversations. Kent and I have had extensive conversations on this. The law as it currently exists is a very enervated, debilitated conception of what it has to do with corporations, right? It's kind of ceded the ground to the corporation to say, we won't actually tackle these things because it's not our problem. If we are accepting this kind of intervention, we need to fundamentally recharacterize the understanding of law and corporations in a way that is not easily accommodative of either the nexus of contracts theory or any of the other dominant narratives of what corporations are about. So I'll stop there, take any questions. Thank you.
Thank you very much for the presentation. Very interesting. I think there are a lot of questions. Okay. No, no.
This is revenge, right? This is payback.
No, absolutely not. Thank you very much. I very much enjoyed your presentation. I'm going to do something that I normally never do in one of these things, and I'm going to plug myself. So one of the reasons I enjoyed your presentation so much is because I just wrote an article on this very issue, which is forthcoming. Okay. And so I'll be happy to talk about that with you individually. But what I thought was really interesting, well, two things. First of all, your conclusion, or the last point you concluded on was, does the law alter the concept of materiality? What do you do with the fact that there actually is significant investor support for the conflict mineral rules? Yep. So I don't know if you can say that it's not material since there is so much support for it. So in my article, I concluded that actually investor support on this issue is mixed. Yep. So that might go towards materiality. And the second thing, which I was curious about, is why did you talk about corporate law theory using the idea of the nexus of contracts? So from what I understand about your background, you are English educated and you worked in Ireland and in Australia. So where is this, what would probably be a law and economics U.S. Dominant theory? How is this pervading your issue? And I'm going to plug Beata as well. So sorry, we're going to do this as well. So we have a forthcoming book called Understanding the Modern Company, which Beata kindly contributed to. I asked Beata to write a chapter on what is the corporation. Is it public or private? And her conclusion is, why are you asking me this ridiculous question? This is beyond the point. So.
Yep, great points. And you raise a lot of very intricate questions to which I don't know if I'll answer as thoroughly as I wish. Should I listen to your question? Is it related, or can I?
Kind of, but not entirely.
Okay.
No, you can answer.
Okay. So I'll just give a quick answer to the question. The point is simple, right? I mean, you're right about investors, and if you look at the number of comment responses to the SEC's proposed rules, the dominant, in fact, there was virtually no resistance from the investors in terms of a response that was hostile to the proposed rules, saying we don't want this, whereas all the industry bodies, etc., did say that. So to that extent, you're right that there is investor support. But whether that investor support is coincidental or expressive of some other sentiment than materiality, I mean, there's many reasons why investors might seek information. That doesn't necessarily mean that it is about whether it affects the decision to invest, divest, et cetera, et cetera. Right? So that's where materiality at the moment has been traditionally is understood as being very closely related to the financial element of the transaction. So that's one part of it. And second, even if to the extent that investors say yes to this kind of rule, there is a great degree of heterogeneity about investors. And it's not possible to capture all of these strands of investor desires through this kind of process to understand whether it's SRI type investors who are driving the agenda, because they have self-interested reasons why they might want to do that. Third, with regard to nexus of contracts and theory, we're talking about a law which is in the US, right? So in that jurisdiction, the dominant narrative is around the nexus of contracts and enabling default rules-based approaches and so on.
I think Ken Greenfield and Lynn
Yeah,
Stout
no,
and
I agree.
everybody
I
else
agree.
disagree.
I agree. I completely agree. I'm not disputing that. What I'm saying is, this strand of lawmaking from the SEC is perhaps an admission that there is something missing in the nexus of contracts type narrative, and therefore it's about whether that explanation still has valence to describe what corporations are about today. So I'm not saying that I believe in the nexus of contracts, but that still is the dominant narrative as we speak. The stakeholder conception, etc., very, very difficult to sell in the US, at least in the mainstream. So if we are moving in a different direction, then it's good to be explicit about it. That's the point I was making.
Thanks, Sandeep, for a very interesting presentation. My question is basically on, first of all, I think that we see a similar issue coming up, especially from the SEC when it comes to climate change disclosure. Again, something that's not within the purview of investor protection strictly, but SEC is taking efforts towards that. So my question is, are we really making an artificial distinction between what SEC should do, or whether these things, is there any problem in these things creeping in? And secondly, is there a way of rationalizing it even in your theoretical model by thinking about the nature of investors as being different from how we traditionally understand? So in your paradigm, investors are profit maximizing entities, but today the way socially responsible investment, the Norwegian pension funds has decided to divest from coal and so on. So I think investors are thinking about their priorities and goals have become different. So in that context, can we say that these disclosures are actually within the purview of investor protection? Because what we think of investors' incentives have changed over a period of time.
Yeah, again, great point. The difficulty for me is I completely sympathize with the normative strand of the argument, but it's very, very difficult to explain investor motivations in that kind of linear sense that you are canvassing, right? So you have the Norwegian funds, you have the divest Sudan funds, you've got the university endowments which divest from tobacco, blah, blah, blah. The problem is a lot of those behaviors can be explained through other exogenous reasons. For example, many of the funds react with sell decisions in the face of extreme pressure from interest groups, etc. So it may not be that the fund necessarily agrees with divesting from oil or Iraq or Sudan or whatever it is, but it's done as a response to pressure groups which are able to capture the narrative and influence behavior. So it's not necessarily clear that the behavior is responsive to some normative commitment, but rather as a response to a pressure tactic. So there it becomes a little more problematic to say whether this is legitimate, because it's coercion, or you could argue that it's coercive, right? That's one point. Second, even to the extent that there is a change in behavior, which I'm tentative about. There's talk about the millennials have different expectations of communities, blah, 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 all of that sort of stuff. The difficulty is when it actually comes to the crunch, investors, consumers, etc., are very unwilling to pay a price premium, for example, for more ethical products. A lot of the business research shows that anywhere more than 10% price premium, investors just walk away, or consumers walk away from products which supposedly are fair trade, green, blah, blah. So how much of it is cheap talk versus actual behavior motivated by the right norms? How much of it is because of pressure, shaming, etc., and whether it's legitimate to use corporate law for these political agendas to shame, etc. Because the risk is these political agendas and fads might change. And then you're left with a corporate law which looks very different from what it was originally designed to do. I mean, George Clooney will change his mind about Sudan and DRC, etc., when the next fad comes up. He might. But if we respond with our corporate law to that fad, then we're changing and altering corporate law in a different direction. So I'm not saying we shouldn't or should not do. I think all I'm saying is we need to have a deep amount of thinking about what corporations are in today's society. And if it is about something which is more than the nexus of contracts, if it's more than about shareholder wealth maximization, we need to find the optimal models of law to achieve those purposes. It can't be through the stealth or sneaking in with incomplete institutions, through incompletely theorized laws, etc. We can go full tilt and create the institutions, create the laws which will accomplish those objectives. But that hasn't happened.
Question will be from the audience afterwards.
Thank you very much. That was a brilliant presentation in the sense that you achieved to provoke quite a few of us in the audience, and that always that's really helpful. You know what caffeine didn't do. And you did. I agree that there's a lot of reasons to criticize this tendency to ask companies to report more, and that's supposed to help through ideas based on reflexive theory. I don't know enough about the American rule. That might be a crappy rule, and it might not be. It might be beyond the mandate of the SEC. That being said, the problem with war economies and business and finance making a lot of profit on war economies, that's not a fad. That's a gigantic global societal problem. And when you speak about when you mentioned the consensus about corporate law theory, I mean, it seemed to, through questions, to then have been narrowed down to the dominant legal economic understanding in certain circles in the US. And if you're speaking on behalf of those, that's fine, because I think there's quite a few of us that you are not speaking of when you say we, because the nexus of contracts, it's a fine theory. I think it's actually quite illustrative. If you imagine a company and it has contracts of various types with lots of different parties, but the problem is with that theory is that has then been taken as this kind of normative argument for not regulating anything, and the company has never been just about it's not a contract. Okay. Okay. That's fine. I'll try to be very brief. I'm glad you said what you said, because it illustrates so well this dominance of the legal economic postulates, and moving away from that is not a paradigm shift. It's a recognition of what we in Europe have seen, except for in the UK, have seen for a very long time. It's traditional continental European law and Nordic law is that the company is more than its shareholders. And since we are about books, I think Ken Greenfield edited a book where he speaks about metaphors that can take over the mind. The Nexus of Contracts is one like that. Yes, and just last one. And since about books, company law and sustainability, we have a chapter there, comparative analysis, really in depth. And there's no jurisdiction in the world that we analyze that has shareholder maximization as a norm, as a legal norm.
Okay,
It's a myth.
Very short answer, and then we'll request the question of Ken in the discussion after.
Yeah, thank you. That was an excellent question. I wasn't saying that the cause of humanitarian sort of desistance from these kinds of behaviors is a fad. I was saying that the laws that are framed in response to these humanitarian crises are because of advocacy by celebrities, blah, blah, blah. Because if you ask the average US investor whether they care about the DRC and the conflict in Africa, they'll say probably not. But because of Clooney or people like that, these things become or rise to the level of political attention where the other politicians seem to be responding to that, etc. So if we rely on these advocates to generate fads which then generate laws, we're running into a risky kind of terrain. That's the point I was making. So if we consciously say, yes, we're really concerned about Africa and how these horrible militias are using supply chains to do all of these things, fine, I have no problems with that. And secondly, I was not advocating for the nexus of contracts theory. I mean, to be very clear, I think it's a very thin explanation for what corporations have been and indeed are today. But I don't think we've reached a point, at least in the US, UK, and Australian law, where a more richer stakeholder type conception of the firm can be accommodated in existing law. I mean, that's the point I was making, because courts repeatedly have stepped away from that. Any occasion that they've gotten to say, consider stakeholders, they've shied away by saying only to the extent that you don't affect shareholders. So,
okay, so thank you very much. We saw that it's an important topic and we could discuss that for an hour longer, but we run out of time. Thank you very much.
Thank you very much.